today by Professor Gerard, founder and faculty director of the Sabin Center for Climate Change Law, as well as Andrea Nishi, Climate Justice Fellow at the Sabin Center, and Dana Johnson, Senior Director of Strategy and Federal Policy in the DC office of We Act for Environmental Justice. With that, I'm going to turn it over to Dana to share our motivation behind this initiative.
Thank you, Annika. Once again, I'd like to thank you for joining us for the introduction of Dismantling Injustice, a model for empowering communities. Our movement, as most know, really works to address the disproportionate exposure to pollution and environmental degradation where people of color and people of low income or low wealth live. When we look across this nation, we can take data from the EPA that shows us when we look at where polluting facilities are sited, when we look at, transportation pollution, fossil fuel or power sector pollution, waste pollution, chemical pollution, 48% of it exists in places where people of color live, and 18% of it exists in areas of low income. And so this issue of the cumulative exposure to pollution is one that is very much important and of interest to our movement, to the environmental justice movement, and our allies and partners across the country. And We Act convenes a network of environmental justice organizations called the Environmental Justice Leadership Forum. There are about 50 groups that are a part of that network. They represent 22 states or so. And in 2020, September 2020, we were hosting our annual convening right on the heels of New Jersey passing groundbreaking cumulative impact legislation. It was inspiring and empowering for our movement. And we had groups across the country who were looking to do the same thing where they live, where they work, where they play, where they pray. We did some initial work to organize our allies, our groups around moving cumulative impact legislation forward. We saw it come to fruition in New York, but it was clear to us that we needed to have something more. We needed to have a bigger opportunity for people. And that's confirmed by a recent research paper that We Act was a part of with researchers and environmental justice organizations across the country. It was published in Science magazine last week, and it looked at air pollution and the policies and the practices that are coming out of the federal government to address it. And one of the key takeaways from that study is that we really need to think about local solutions, local tools, local policies, local practices, if we are going to address the racially and economically disproportionate exposure to pollution that we see happening across this nation. And so I believe that the model bills, the package of bills that we are going to share with you today are that local solution. It's what we need. And so we look forward to rolling them out, to answering any questions that you have around them. And I'll pass it back to Annika for next steps.
Great. Well, we know that I was going to say thank you, Dana. We know the Sabin Center for Climate Change Law was already doing this sort of work to develop model bills to be adopted by localities and states to address a variety of issues. So we thought it was very important to partner and develop a set of environmental justice bills. So I want to transition next to both Professor Gerard and Andrea from the Sabin Center for Climate Change Law to discuss the bills and what they do.
Thanks very much, Annika. As Dana just said, there are high levels of air pollution and water contamination in many disadvantaged communities. This is largely because so many polluting facilities like power plants and factories are located there that directly cause pollution, and also because facilities that attract a lot of vehicle traffic, especially heavy-duty vehicles, locate there or alongside there, like warehouses and bus depots. When building these kinds of things, some cities and towns require environmental review of some sort, but typically they just look at one project at a time. And the question they ask is, will this one project have a significant adverse environmental impact? But in many places, it's the accumulation of polluting facilities that creates the problem, their cumulative impact. Looking at just one facility at a time makes it easy to overlook this cumulative impact. One of the draft bills that my colleague Andrea Nishi will talk about when I'm done would require state agencies to issue studies and maps showing areas that are disadvantaged and that are suffering from disproportionate pollution impacts. Another bill would require the state, after it has identified the facilities that are contributing to this disproportionate pollution, to try to come up with a plan to reduce the pollution. That could involve relocating or closing the facility if that's legally possible. Otherwise, it might require, for example, improvements to their pollution control technology used at the site, or a reduction in waste streams, or diversion or reduction of vehicle traffic. Shutting down existing facilities is very difficult, even if they're very dirty. Many of them enjoy grandfather status, meaning that they can continue to operate under old standards, even if new, tougher standards have been adopted since the facilities were built. One of the objectives of the Clean Power Plan, which was issued by EPA under President Obama, was to shift a lot of the electricity generation away from dirty power plants, especially those that used coal, to cleaner sources of electricity. The Supreme Court halted that plan in 2016. The Trump administration repealed it, and the Biden administration said that it was going to come up with a new plan. But a year ago, the Supreme Court jumped in, said EPA didn't have the power to issue the Clean Power Plan in the first place, and the court more generally limited EPA's powers. The Biden administration has proposed a replacement plan, but it's only aimed at the power sector. It doesn't apply to other pollution sources. It, too, will almost certainly be challenged in court when it's issued in final form. And it won't take effect until several more years, even if it does survive the challenges in court. This past May, the Supreme Court issued another decision, this one on wetlands, that further limited EPA's powers. But these decisions, both the one on the Clean Power Plan and the one on wetlands, made clear that the states are free to impose their own pollution standards and can go beyond EPA and other federal agencies. There are a few exceptions, most importantly for emission standards for motor vehicles, where state powers are more limited. But for the most part, states can act on their own. So the bills we're presenting are all state laws, and many of them empower the cities and towns within them to take further action. We're concentrating at the state level also because this Congress is not going to do much more on the environment than it already did a year ago with the Inflation Reduction Act. And also because depending on the outcome of next year's presidential election, the federal government might be softening or repealing the regulations that are now on the books, or just not enforcing them, all of which happened after Trump took office in 2017. Most power plants and other polluting facilities have permits from state environmental agencies. Many of those permits require periodic renewal every 5 years or so, for example. Our bills require cumulative impact review at the time of renewal or major modifications. This could help states shut down polluting facilities or require them to pollute less. Many of the disproportionate impacts on disadvantaged communities come from vehicular traffic. The federal government regulates permissible pollution levels from new motor vehicles, but has very little power over existing motor vehicles, and it has little or no control over the construction of most of the facilities that generate a lot of traffic. And in some places, some facilities that generate a great deal of truck traffic, such as warehouses and distribution facilities for Amazon and the like, don't even have to go through the local approval processes. In some places, they are called what they have as of right status, which means that if they're consistent with local zoning and don't require any variances, they're entitled to a routine building permit without public hearings or any other discretionary review. And even if they are not as of right, even if they do require discretionary approvals, they don't usually require an especially rigorous review that studies the effect of traffic on the nearby communities. Our bills would fix that. They would say that any new facility or significantly modified facility that generates a large amount of traffic in an overburdened community would require a review of its traffic impacts, and conditions would have to be imposed to minimize that traffic impact, and public hearings would have to be held. And if the review showed that the facility would cause more than a specified amount of added pollution in an overburdened community, the construction or expansion could not go forward unless the project is for the public interest of the community and no suitable alternative site exists. So now I'm going to turn it over to my colleague, Andrea Nishi, who's a lawyer who works with me at the Sabin Center, to talk more about the details of the bills themselves.
Thank you, Professor Gerard and Annika and Dana, for that background on the issue of cumulative impacts, and also for exploring the legal reasons why this set of bills has the power to be so impactful in this area. As Professor Gerard mentioned, the issue of cumulative impacts is really about the potential for multiple different sources of pollution and other environmental stressors to impact public health in a single community. Exposure to common pollutants can lead to a variety of health impacts, including cancer, heart disease, infertility, asthma, and developmental disorders. These effects can be compounded when a person is exposed to multiple sources of pollution and other types of environmental burdens. Oftentimes, these overlapping burdens are more likely to exist in low-income communities and communities of color. So to address this issue, we've put together a package of 5 model laws, each one addressing a different facet of the cumulative impacts issue. And because these are model laws, they're intended to be a baseline for different jurisdictions to use and alter in ways that help to address specific needs of the local communities. The first bill that we've put together is one establishing an environmental advisory board at the state level. This board is intended to act as an entity within the state government that's focused on advocating for environmental justice in disadvantaged communities, and also serving as an expert resource for policymakers within the state government. Membership of this board draws from a lot of different areas, but there's a focus in the bill on both residents of impacted communities as well as environmental justice advocates. And appointments to the positions on the board can be made by the governor of the state as well as members of the state legislature. The board is required to meet at least once per quarter and also has to continue operating even when vacancies on the board arise. That way, the board is continually operating and meeting the responsibilities that are outlined in the bill, even if there are open seats on the board. That said, the board has a wide variety of powers and responsibilities. Those include raising awareness of different environmental justice issues, suggesting process improvements for public engagement, particularly focused on communities that do bear disproportionate levels of pollution. The board also is enabled to provide guidance and advice to policymakers, as well as submitting formal comments in policy proposals and permitting decision making. The board also has the ability to host public meetings whenever it feels there's a need to gather community perspective on different environmental justice issues, and can then submit the input from those meetings to different decision makers within the state government. And finally, the board also has the ability to propose new policies, process improvements, and capital projects that can help address the environmental justice issues that they're seeing on the ground that aren't being adequately addressed within other parts of the state government. So that is the Environmental Advisory Board in a nutshell. I'm happy to take questions about specifics of that bill in the Q&A box as well. Astrid, would you mind moving to the next slide, please? Thank you. So the next bill focuses on cumulative impacts reporting, which is intended to increase transparency and accountability around the issue of cumulative impacts within the state government. So this bill accomplishes a few different things. The first thing that it requires is that the State Environmental Protection Agency, or whatever the state agency is called that refers to kind of environmental conservation matters, that agency is required to identify environmental justice areas within the state and publish a list of them on its website. The bill outlines how those areas are to be identified, and it focuses on a few different criteria. The first is the demographic makeup of the community, which looks at the sort of proportion of the community that's low income, that features a certain threshold of minority residents, that features a high proportion of residents who have not completed high school or who have limited English proficiency. So those demographic characteristics are one way that an environmental justice area might be identified. But the bill also allows the agency to identify environmental justice areas based on federal metrics that determine the susceptibility of the area to different environmental harms. Finally, the bill also allows for tribal lands to be included in the list of environmental justice areas, and then also includes a provision that allows the state agency to use its own discretion to identify other areas that may not have been captured by the metrics that we've laid out in the bill. So that provision is especially important because it allows for environmental justice communities to self-identify with the agency and explain why they think that they should be included in the list, even if they don't meet the criteria that are laid out in the bill. So all of those criteria are what are used to put together the list of environmental justice areas that the state will publish on its website. And on the whole, those metrics are used to identify the areas that are at the highest risk of being overburdened by pollution, or where communities may not be as equipped to participate in the public participation processes that are in place to help them advocate for their own environmental needs. The production of that list also features a public comment period that allows for members of different communities to give input on the list as it's being assembled, and just to allow different communities, as I said, to self-nominate and make sure that their voices are heard and that the issues that they're facing are addressed in the list as well. The next component of the bill is that the agency takes the list that it's put together and creates an interactive mapping tool that's also going to be publicly available online. That tool shows the locations of the environmental justice areas that have been identified, as well as the locations of different kinds of polluting facilities and different kinds of polluting infrastructure that are identified in the bill. That can include things like waste management and processing facilities, as well as a bunch of different facilities that operate under federal environmental permits. In addition to showing the locations of those facilities, the tool also features a search function that allows members of the public to look for different kinds of facilities within the tool and see where they are in reference to the environmental justice areas that have been identified. The tool also features the location of what we call community exposure points, which are different locations where vulnerable members of the public may be more likely to spend time. So that includes places like schools, churches, community centers, hospitals, homeless shelters, all kinds of different locations like that where there may be more vulnerable people gathered, where you would want to see where those places are located in relation to environmental justice areas and in relation to the different polluting facilities that I mentioned. The big heart of the bill, though, is what we call the cumulative impact report. That is a document that the state agency has to compile and publish every 4 years, looking at the different sources of pollution in the state that might impact the environmental justice areas that have been identified. So for each of those potential sources of pollution, the report will look at how different people in the community might be exposed to that pollution and what the potential health effects might be as a result of that exposure. The agency is also required to supplement that report with different recommendations based on its own expertise about how it can mitigate those sources of pollution and reduce the impact on communities. So that could include something like improving the technology that's in use at the facility to help control the pollution, or something like relocating or even closing the facility if there aren't steps that can be taken to really reduce the impact in other ways. For each new edition of the report that comes out every 4 years, the agency is also required to address the recommendations that it made in the previous version of the report and explain what steps it's been taking to implement those recommendations, or explain why it hasn't acted on those recommendations over the last few years. And these tools, both the mapping tool and the report, are intended to inform the public about the issue of cumulative impacts and what steps the state is taking to address that issue. But it's also intended to serve as a tool in agency decision-making processes. The bill requires that the agency consult with both of these resources throughout its decision-making in order to make sure that the issue of cumulative impacts really remains top of mind throughout the agency's decision-making in general. Astrid, could you move to the next slide, please? So the next 3 bills that I'm going to talk about all have to do with permitting or other kinds of government approvals. And the way that we've structured these bills, they each share a very similar mechanism for when the agency is going through the approval process. So what I'm planning to do is speak generally about what each of these 3 bills accomplishes, and then afterwards I'll speak about the approval process that they all share. So the first of the 3 bills relates to indirect sources of pollution, which are facilities or other kinds of development that can attract a lot of vehicle traffic, as Professor Gerard was discussing. So one example could be something like a stadium that may not emit a lot of pollution on its own, but attracts a significant amount of traffic that can be a huge source of air pollution in the surrounding community. These kinds of facilities are an increasing problem with the expansion of e-commerce, since there's more of a need and a higher demand for warehouses and distribution centers located very close to residential areas. And because those facilities attract a lot of truck traffic, that can really increase air pollution in the area around those facilities. So the way that this bill operates is it targets different facilities and roadway construction based on either the expected amount of traffic on the roadway, the number of parking spaces at a facility, or the square footage of a warehouse or distribution center. And whenever a facility or type of construction that fits those criteria is located in an environmental justice area, a new permit is required for the construction or expansion of that project. And I will talk a little bit more, as I mentioned, about what that approval process looks like in just a moment. And Astrid, could you move to the next slide, please? So the next type of bill that we're working on is the as-of-right zoning bill, which Professor Gerard discussed a little bit earlier what the issue of as-of-right zoning entails in environmental justice areas. But essentially, as-of-right zoning allows for development without a lot of additional discretionary review from a local land use agency. And what this bill does is it limits as-of-right zoning in environmental justice areas. And what that means is that whenever there's a proposed land use that could contribute to negative environmental impacts in an environmental justice area, that facility now needs to go through an additional permitting process that requires the agency to review the potential impact that it might have on the area, when otherwise it would not have been able to do that, because the as-of-right zoning that was in place allowed the building permit to be issued without a lot of discretionary review from the local land use agency. And unlike the indirect source bill that I just mentioned, this bill is not focused on a particular type of facility, but rather is looking at all types of polluting facilities that could negatively impact an environmental justice area. And again, I will speak a little bit more in a moment about the permitting process for these facilities. Astrid, could you move to the next slide? Thank you. So the final of the three permitting bills that we've put together has to do with permit renewals. And as Professor Gerard mentioned, the issue of grandfathering is a huge source of concern for a lot of environmental justice areas because existing facilities that have enormous pollution burdens for the surrounding communities are often able to continue operating under older, less stringent, outdated environmental regulations, even when more strict regulations are in place for the development of new facilities. And what that means is that oftentimes the operation of an existing facility can pose more of an issue for the surrounding community than the possibility of building a new facility in the area. So this final bill targets that issue specifically by imposing new permitting requirements and permit renewal requirements for existing polluting facilities that are within a set distance of designated environmental justice areas. Under this bill, these facilities are required to apply for and renew a new type of permit once every 5 years. And as a part of that permit renewal process, the state agency that's overseeing the permit renewal is required to assess the facility's role within the broader context of the community and cumulative impacts in the area, and also to examine different developments in pollution control technology and regulatory standards that have come into place since the facility began operating in order to think about what can be done to really mitigate the pollution from the existing facility. Astrid, could you move to the next slide, please? Thank you. So as I mentioned, these three bills, the indirect source bill, the as of right zoning bill, and the permit renewal bill all feature a similar permitting process that outlines the steps that the agency undertaking the review needs to go through in order to approve a given project that's subject to the bill. So the first component of that process is public engagement. So we've built in a lot of different steps that the agency needs to take to solicit comments from the public and to make sure that that solicitation is casting a wide enough net to really capture the perspectives of a lot of different community members, regardless of the language they speak, where they might see the notice for the public comment period, how they might like to submit the comments that they have, and elements like that that may generally be kind of exclusionary in other public engagement processes. So we've attempted to craft a process that's really inclusive and allows a wide variety of people to submit their perspective. So the agency needs to solicit public comments and also in many cases host public hearings that allow people to provide their feedback in person as well. In addition to the public engagement process, the agency needs to make at least one of two specific findings in order to approve a project under any of these bills. The first finding that they can make is that the project will have a minimal impact on the environmental justice area. And so in many of the bills, we've set specific thresholds for what that impact looks like. Although, as I mentioned at the beginning, these bills are intended to serve as a model, and those thresholds can be adjusted based on the specific needs of each state that is looking to pass this legislation. So that's one finding that the agency can make in order to approve the permit. But alternatively, in the case that there is potentially a greater impact on the environmental justice area, what the agency needs to do is determine that the project is necessary for the public interest of the area and no suitable alternative site exists for the facility. And because that involves a public interest determination, it's important to kind of focus on what exactly does the public interest mean in this circumstance. So the bill highlights that this determination is really intended to focus on the full scope of the environmental justice area's needs, which can include the need to be free from pollution. And what this is intended to accomplish is make sure that projects aren't going to be approved solely based on kind of vague economic benefits that may never actually materialize, which is an issue that many communities have run into in the past with the permitting process specifically. So as I mentioned, the agency can either determine that there will be kind of a minimal impact on the area or that the development is ultimately going to be in the public interest of the area. That said, a big part of the permitting process that we've developed is giving the agency the ability to put conditions on the issuance of a permit. And so for each permitting determination, the agency is going to place reasonable conditions on the permit approval, which could include something like requiring the use of specific pollution control technology at the facility, but could also include something like a specific community engagement process that ensures that the facility is going to continue having a dialogue with the community that could be impacted and listening to their concerns and suggestions about the way that the facility is operating. Another component of the approval process is that the agency can look to the existence of community benefit agreements as evidence of what the public interest actually involves. So in some cases, if the community has entered into one of these agreements with the developer, that could be evidence that the development of the facility is in the public interest. But in some cases, these community benefit agreements are in place and developers may not always follow through with the agreements that they've laid out with the community. So particularly with the permit renewal bill, if a community benefit agreement is in place and the facility's developer or operator hasn't been abiding by the terms of that agreement, the agency can also look to that as evidence that the continued operation of the facility isn't in the public interest. Finally, as I mentioned, the agency has the ability to place specific conditions on the issuance of the bill. And so that is kind of the permit renewal process in a nutshell. And I'm happy, as I said, to take questions in the Q&A about how any of these bills functions in more detail.
Great, thank you so much, Andrea. And with that, we'll go ahead and transition to the Q&A. Astrid, if you don't mind switching slides, thank you. I see we have a couple in the chat, and please feel free to keep putting them in the chat or raise your hand. But the first one is from Alexis Jones, and thank you so much for your question. Would the advisory board report up to a federal level? What would make the state listen to their suggestions? And do you see it being a limitation for local individuals having to run the board, as those in environmental justice communities are already facing a lack of time due to trends associated with being POCs and low income? I'm going to direct that to someone from the Sabin Center. If you guys want to jump in and answer.
Sure, I'll start. So the advisory boards are designed to be at the state level and report up to the state agencies. And one thing that has been pointed out is these are model laws that would have to be adopted for each state. Each state has its own procedures and so forth. So if it's in a state where there is a lot of concern that the state won't really listen to the advice of the advisory board, I could imagine adding language saying that any agencies to which an advisory board is addressing its advice has to consider the advice and come up with a written response as to whether or not it's going to take the advice and why or why not. That one could imagine that being an added provision. You rarely see that in legislation on advisory boards, but it could be added. Clearly, the people in these communities who are active in these issues have limited time, and I think the questioner is quite right to raise the concern that will there be people who have enough time to actually serve on the advisory board in view of all their other responsibilities, and that's a legitimate concern.
Yes, I will just add to that on the point about sort of the time constraints on people who may be participating in the board. One of the features that we've built into the model law is that members of the board can be reimbursed for their actual and necessary expenses that they incur in the performance of their duties. And the way that we've envisioned that provision is that it can be read fairly broadly to cover things like lost wages, lost tips, or other forms of income, as well as expenses for things like commuting or childcare. So we hope that that can help kind of defray the costs for some people who may have limited resources or limited time to enable them to participate in the board more fully.
Hi, this is Dana. I'd also add to that. I do think that we have to have considerations around the amount of time that people have available. And I appreciate the incorporation of, compensation or reimbursement in the draft legislation that we've developed. I think also we must consider that people are already doing this work out of a desire and passion to have better living conditions for themselves, their family, and their communities. So while I don't think that this is, I don't think that this will be a stress for people, a stretch, I'm sorry, for people who are already doing the work. And so I hope that we don't get stuck on a time concern. I feel like that is oftentimes brought up when it comes to environmental justice advocacy. And I think that people are already doing the work.
Thank you. The next question is, the problem with state action versus federal is that it tends to be the states that have the most environmental justice issues that do not want to support these types of bills. And there is no federal level power to say you need to change. These bills are a good start for progressive states, but what about the less progressive states? I will direct this to first the Sabin Center, and then Dana, if you want to jump in as well.
So that's a very valid concern, and there's no way that we could force Texas or Oklahoma or West Virginia to, for example, to adopt these laws. And ultimately, one would hope for a federal solution, but that obviously depends on the electoral results, but who runs Congress and the administration. I don't have a real solution to that other than the politics.
Perfect. Thank you for that answer. The next question is, can you discuss thresholds in greater detail that would mandate action? Andrea, I'll pass this one to you.
Yes, I'm happy to take this one. And if I understand the question correctly, I think that this participant is asking about the sort of de minimis thresholds that I mentioned for approving a permit, when I said that the agency could either approve the permit because it has sort of a minimal impact on the community versus approving it because they've made the public interest determination that I mentioned. So if that's what this person is asking about, yes, I'm happy to talk about that. And essentially, each of the three sort of permitting bills has a different threshold. And for example, the indirect source permit bill has specific thresholds for different types of pollutants. So it essentially states that the agency needs to make a determination that the activity associated with the indirect source is not going to generate more than a certain annual average of carbon monoxide, lead, nitrogen dioxide, and a list of other pollutants. So that's more or less how that bill functions. And as I said, each of the bills has its own sort of like unique thresholds for making those determinations.
Thank you for that. I see right now that we don't have any additional questions in the Q&A box. If anyone has questions they would like to ask, you can go ahead and also raise your hand and I can unmute you. We'll give it a couple minutes, and then if not, we'll transition out. Oh, great. I see Alexis. All right, Alexis, you're welcome to ask it.
Hi, thank you guys for holding this today. My next question is there a way to include language in these bills that make facilities pay for the cleanup for the pollution they've caused? Because I'm just thinking about a lot of the times the money for, well, in one of the bills you talked about the ability for there to be like reparations made when there is pollution, but a lot of the times the money for those types of cleanup projects come from taxpayer dollars, which is coming from the EJ communities who are being affected by this pollution in the first place. So maybe also looking at the facilities paying for the cleanup could also be a way to disincentivize them from creating that pollution in the first place.
I'll start with that. I mean, of course, the federal Superfund law, CERCLA, does require polluters to pay for the cleanup in those sites that are, on the national priorities list. As a matter of state law, the states would have the power to require um, um, people who were involved in other kinds of pollution to pay. That would be a matter of state law. It is an additional leap in terms of legislative action. There are proposals pending in some states, including New York State, to do that kind of thing, to have various ways of charging polluters for their pollution on top of what we already have. I would think that would probably be a separate bill. It would be subject to its own political and other issues, but it would generally be within state power to impose that kind of a fee or tax or penalty or whatever you want to call it.
Yeah, I think I would add to that. There is or at least in the last session of Congress, there was a polluter pay bill that was introduced. I believe one of the sponsors was Senator Van Hollen. I would have to double check that. But I do think that it goes back to the earlier comment that Professor Gerard made around, political will. And I think that same thing applies to the earlier question you had, Alexis, around less progressive states. We can't disconnect this work from a civic engagement process. And if we have a disempowered electorate, then these types of bills being picked up, adopted, and tweaked to address the unique conditions in different communities, they won't move forward, they won't advance. So I have to put the plug in for bills like the recently reintroduced Freedom to Vote Act, because that bill is designed to address the more than 400 voter suppression bills that were passed during in the wake of the 2020 election. And it gives people the power to be able to partner with their legislators, or to ensure that they have legislators in place that will pass the kind of bills that and to address the challenges that these model bills are designed to focus on.
Thank you. And Ms. Mitchell, I see you have your hand up as well.
Yes, thank you. I wanted to just make a comment about the community benefit agreement and how we can strengthen our agreement, because one of the things I'm noticing is that there's lots of funding that would go to the bricks and mortar of these projects, building up and tearing down and landscaping and all that stuff. But the public health and for the people's good and health and wellness, how might we really push in those areas for more the indoor quality, the impact of substandard housing that is causing many families to experience high level of asthma and those types of things, lead, mildew, mold. And sometimes we don't have the necessary support to deal with mold and mildew, even at the local level. And people in the community have these hardcore issues that they are faced with every day. And so just general recommendations, how you see we might strengthen our capacity to address those areas.
So I think I'm not quite sure if you're talking about an existing community benefit agreement or the design of something new. And I think that process can be done in a variety of ways. If one were to adopt the draft legislation that we have put forward, but ideally it would be the community with a project developer, for example, and maybe a state agency or some sort of state representative facilitating the process of getting to a mutually beneficial and a mutually agreed upon set of benefits. And I don't think that there are limitations to what those benefits are. So if there was a desire to ask for something in relation to housing, or indoor air quality, I think that those things can be on the table and they can be negotiated as a part of that benefit agreement.
Could
I
add
agree
to
with that.
Oh, go ahead,
Uh,
Mike.
I'll just say that one could, again, draft legislation that would require the inclusion of that. Getting the votes for the legislation is another issue, as we've talked about. Andrea?
Yes, thank you. I was just going to add that, yes, the community benefit agreements are definitely relevant under these bills, but they aren't necessarily the end all be all of the decision-making process. So if, as you mentioned, there's sort of a brick and mortar agreement in place about the design or the construction of a given facility, but members of the community don't feel that that agreement necessarily reflects all of the concerns that they have, there is still a very robust public participation process in place under the bill where they can raise those concerns with the agency that's making the determination. And in that case, the existence of the community benefit agreement that's focused on those sort of design and implementation features that you talked about, that could be sort of downplayed because of the strength of the community input around the other issues that you mentioned.
Thank you. And next I see Arif, you have your hand up. I'll turn it to you.
All right, great. Thank you, Michael and Andrea and Dana and everyone for this really, really valuable work. It's, I think, going to help cities and states across the country. This question is somewhat specific to the South Bronx. So I'm with South Bronx Unite. At the moment, we're challenging the re-permitting of a peaker plant site, and the site seeks a renewal permit every 5 years. And you mentioned that, Michael, earlier in your presentation. And we're asking the New York State Department of Environmental Conservation to take into consideration Section 7.3 of New York's Climate Act, focused on disproportionate burden. And DEC, you already know, they're sort of creating guidance around that, and we're pushing them to do that. We're also asking DEC to uphold the spirit of the recently passed cumulative impacts law, which, Michael, you played such an important role in informing. So thank you for that. So my question is a bit general, and this is where it applies to everyone, I think. After good legislation is passed, of course, other processes begin. So if you have some recommendations on how EJ groups like ours can make sure that good legislation is implemented well, what types of processes to engage in, et cetera, that would be really helpful. Thank you.
So New York's Climate Leadership and Community Protection Act provides for the ability of people to sue. And so if DEC or another agency is violating the law, there's the ability to go into court to challenge that. I think that's one important measure. Not every state has a similar kind of provision, but fortunately New York does have this kind of thing. And I agree with you that the application of the CLCPA to the renewal of these peaker plants is going to be an important issue, and we may well see litigation about it.
Great. And the next question I see is, I am still confused on what removes the grandfather clause. Just the states writing in ledge text that they will not allow it? Can you explain this again with some more context, please?
Yeah,
Sure,
okay, I'm sorry,
go
go
ahead.
ahead, Andrea. I'll let you do that.
Okay, yes, I was just going to say that, so this is a question about the permit renewal bill specifically, I think. And so the grandfathering issue that Professor Gerard explained is essentially that some facilities are allowed to continue operating under sort of outdated regulatory standards, even though new standards might be in place for the development of a new facility. And so what this bill does to address that issue is, so I think your question was, is it just the states writing in the legislative text that they won't allow that? So yes, this bill is essentially a new piece of law that will override that grandfathering for existing facilities and put in place a new requirement that as those facilities continue to operate, whenever they need to renew their permit under existing laws, they need to go through these new steps assessing the impact that they have on the surrounding communities and ways that they might be able to limit the pollution that is emitted by their facility. And in the case that the facility is normally subject to an automatic permit renewal, that will no longer be the case. And for facilities that don't ordinarily have to go through any kind of renewal process at all, that is also going to be overridden by this bill, and they will now need to go through this permit process every 5 years.
Yeah, that's an excellent explanation. I mean, one reason why we often have these grandfather provisions is the concern by the government that if they do shut down an existing facility, they'll be sued for having engaged in a taking, in removing all the economic value of property. And so you could get into some litigation about that, but certainly a legislature could revoke that and then see what happens.
Great, thank you. We have another question in the chat from Alexis. For permitting renewal, who is allowed to vote for the public interest piece? Is it everyone in the area or just the individuals who live in the environmental justice area? I'm asking because I fear POC low-income voices could get drowned out with votes from other people who are not living in this community, but potentially voting for the project to pass for economic reasons.
I'll start. It's not a vote. It
Yeah.
would typically be the permitting agency that would make that determination, and that determination could then be challenged in court. But that's the agency that would make the determination, at least in the first place.
Mhm.
Yeah, and if I can add a little bit to that, while it isn't a vote, there is a public participation process involved in granting the permit renewal. And so there is a lot of opportunity under the bill for members of the affected community to raise their concerns about the continued operation of the facility. And a lot of the sort of promotion for that public participation process is really focused on the impacted community itself under the bill. And so that will hopefully draw a lot of interest from members of the community and give them an opportunity to share their concerns. And the agency is required under the bill to consider the input that it receives through that process.
Great, thank you. And I think with that, we can close out the Q&A portion. Feel free, of course, to email anyone at the WEAC team. I can share my email in the chat as well. With that, there's much more to come with our initiative, Dismantling Injustice, a model for empowering communities. You can stay up to date by visiting our website at dismantlinginjustice.org, or Astor, if you could go to the next slide. There's a QR code on the screen that you can also use to visit the site. You may also subscribe to our newsletter, and we will have a press release going out following this, so feel free to share that as well. We will be launching a webinar series where you can learn more about the challenges and opportunities related to cumulative impacts and practical strategies for advocating change within your locality or state. And we also hope to learn from you by offering opportunities where you can actively participate and contribute to the ongoing discussions and initiatives surrounding cumulative impact legislation. We will have additional resources published in the fall and winter, including toolkits, guides, and case studies, which will share real-world examples and provide opportunities to gain valuable insights to drive change in your community. As a reminder, the model bills are templates. They are a tool to, build from, and communities may amend the bills to best reflect their individual needs. Like I said, you're always welcome to reach out to me, and we can, help with any of the questions that you may have around this. And we are going to also be posting this webinar to the website. So again, on behalf of We Act for Environmental Justice and the Sabin Center for Climate Change Law, I want to thank all of you for joining today to learn more about dismantling injustice, and I hope you have a great rest of your day. With that, we can close out a little bit early. Thanks, everyone.